Hello, I operate a TS company and have a couple of employees working at one of my clients. They've been working there for more than 4 months. One of my clients does not like one of my employees, and he has now shut him off the premises and disabled his access to the premises. What can I do now?
Okay, Yaku, that's my kind of employer. He doesn't like that employee, and he says, "I don't want you on my premises. You're not in my employ." He thinks
Yeah,
might be his thinking, and get off my premises.
yeah,
Temporary service employer is involved.
yeah.
What do
This
you
is
do?
a very complicated situation. It's not uncommon, but it is complicated due to the complicated nature of the relationship between the TES and its client. Um, Prior to about 2018, the relationship was that the employee of a TES remains the employee of the TES, and the TES simply places that employee at his client, and the TES is responsible for discipline and all that. After 2018, the Constitutional Court interpreted what they call the deeming provisions of the Labour Relations Act, and basically said that the provision in the Act that states that after a period of 3 months, the employee of a TES is deemed to be the employee of his client should be interpreted that the client now becomes the sole employer of that employee for purposes of the Labour Relations Act. That's the one aspect. And that has been interpreted recently by the CCMA to mean that the TES can't even discipline this employee. It's the responsibility of the client to discipline him. So the fact that he is a TES employee or a deemed employee does not take away his right to fair labour practices. So that, if that interpretation of the CCMA for the Commission is correct of the assigned services case, then the TES can't do anything. The client should actually discipline that employee or have a valid reason to discipline him, have a hearing, charge him with misconduct, whatever the case might be. We don't know the facts why he doesn't like him. But that is the responsibility of the client now, it seems, not that of the TES. The second issue with this is what they call a dismissal at the behest of a third party, where there's a commercial relationship between the TES and his client, and part of that commercial relationship says that if the client doesn't like the employee, I can tell the TES and he must remove him. That, the court has said, is not a valid agreement. It's not a valid clause because it undermines the constitutional right to a fair labour practice. If there's not a fair right to remove that employee, a fair reason, I beg your pardon, to remove that employee, the TES cannot do it. And the court has gone so far to say that the TES should take his client to court to prevent him from forcing him to remove that employee. If there's a valid reason, it can be done, but if there's no valid reason for the dismissal, it's not permitted.
To an extent, that defeats the object of employers making use of temporary service providers.
And unless it's a true temporary service, unless it's for a period less than 3 months, or for a position, somebody that's filling in temporarily for somebody that's absent, or unless there's a collective agreement that states that this type of position or this type of job is of a temporary nature. That's the only scenarios where it is not regarded as permanent employment after 3 months. And that's the only scenario how TES can actually perform in the labour market at the moment.
The point is, Yaku, employers used to make use of temporary employment service providers to escape the responsibilities that they had in terms of the normal employer-employee relationship. But this is clearly very complicated now. So it's almost dangerous if you're under that impression that you can dismiss easily.
The court says you can't deal with people as commodities any longer. That's the reason for this change, or this shift in policy rather. People cannot be seen as commodities, and you cannot take away their rights.